Hello and welcome everyone to this LCR webinar. Our plan today is to give you a good general overview of the EB-5 Immigrant Investors Visa Program, provide some basic information, but also answer some of the more sophisticated questions we often hear from our clients, and leave some time to take questions from you specifically at the end. We're looking to go 45 minutes or an hour, and of course, welcome any questions during the presentation, as I'll explain in a second. My name is John Baker. I'm the CMO of LCR Capital, and as most of you know, we are a private investment and advisory services firm that focuses on helping families go global, particularly with the EB-5 Immigrant Investors Visa. In fact, we've helped over 1,000 people move to the US, and have over $300 million in assets under management. We consider ourselves advisors, and our services go beyond the EB-5 visa. We have affiliated companies working with mortgages for foreign nationals that have difficulty getting credit in the US. We work with a number of partners. We have an affiliated company, which is wealth management, and a number of other partners that help families when they decide, particularly to move to the US. Some quick general housekeeping. First of all, we are recording today's session, and we will make the video available, so don't worry about taking notes. We also will take questions, as I mentioned, as we talk. There's a Q&A button in the webinar program. Many of you have participated in Zoom webinars at this point. Feel free to use it. As I said, we'll work questions into our conversation, and or take questions particularly right at the end. So I am thrilled to have with us today Nicolai Hinrichsen, who is known in the EB-5 industry. Has over a decade of experience, and is an immigration attorney with Miller Mayer, a firm in New York State. Nicolai, would you like to say hello and do a quick introduction of Miller Mayer?
Yeah, thanks, John. Very glad to be here. Happy Halloween to everyone. I decided to dress like a lawyer to fit my part. So yeah, my name is Nicolai Hinrichsen. I am managing partner of Miller Mayer's EB-5 practice. Miller Mayer has been involved in the EB-5 industry really since the beginning of the program way back in the 1990s. We were founded in 1985, and our immigration practice was founded by a man named Stephen Yale Lair, who is a renowned immigration attorney, very well known in the industry, both for EB-5 and immigration generally. He's a professor of law at Cornell. He publishes a 20-volume immigration law treatise. He's the founder of IIUSA, which is one of the largest trade associations advocating for EB-5. And he's a professor at Cornell as well. So very, very distinguished individual in the industry. We began really to get traction in EB-5 in 2008 when the program really took off. And by 2013, I was spending a lot of time in China, and at the time decided to open our office in China. So I was based in Shanghai for 4 years, then 2 years in Ho Chi Minh in Vietnam, and then I came back to New York State during COVID. So here I am today. By volume, we're probably one of the largest EB-5 law firms. To date, we've filed over 7,000 I-526 petitions, resulting in probably well over 12 or 13,000 green cards for individual investors and their family members.
That is a big number. And of course, you also do other forms of immigration law, the other classic visas of E2 or even family reunification.
Yeah, we do. Yeah, we do all employment-based and family-based categories. We have a very robust employment-based practice. I focus primarily on EB-5, but we have other attorneys and other groups that focus on other areas of immigration law.
Fantastic. Well, Nicolai, thank you for being here. Before we dive in, I do need to make a couple disclaimers. So if you'll bear with me for a second, the EB-5 visa is based on an investment, but this presentation, this marketing presentation, does not constitute the offer to sell securities. If you're interested in seeing project investment documents or learning more about specific projects and the investments in them, we ask you to contact us directly, contact LCR directly. First, we can confirm that you're an accredited investor if you're in the US or equivalent in your country. And we can also then work with you to understand what you need rather than providing just a standard document. We have multiple projects that we represent, and we like to focus them on you and your family's needs. Second, we obviously will be discussing areas of immigration law, and we have Nicolai with us, but none of this conversation or Q&A can be considered legal advice. I think everyone understands that to receive legal advice, you need to enter into a contractual relationship with Nicolai or an immigration attorney. And at that point, you are receiving legal advice. That applies also to the Q&A. I know frequently people want to ask very specific questions about their case. In general, when we respond to those, we will genericize them a little bit, but we also do want to answer your questions. So, do please ask them. Just recognize that it's not legal advice in this forum. So jumping in, I thought it would be nice to start with sort of just a quick, discussion, Nicolai, about things that we can be optimistic in the EB-5 industry. A lot has happened in the last even 5 years, and particularly last year with the reauthorization and the passing of the Reform and Integrity Act. I know personally, I think the most exciting thing I'm seeing happen in the industry is the improved processing times. Just quickly, what do you think are the most interesting things you're seeing in the EB-5 industry right now?
Yeah, I think it's a great time to be a new investor in EB-5. I've been around this industry for a long, long time, and I'm not sure if this is EB-5 2.0 or 3.0 or 4.0, but clearly we have reached sort of a new level of sophistication, I think, and history. It's always been a very popular program among both Democrats and Republicans in Congress. Of course, as with any moneyed industry, people have wanted to make improvements over the years, and they succeeded in doing that. Congress succeeded in doing that in March of 2022 by passing the EB-5 Reform and Integrity Act. And, Reform and Integrity says it all. It's really a piece of legislation that significantly increases oversight and reporting obligations, and all of these things are really focused on new investors. So I think that's really good, and that's exciting for new investors, giving them certainty about a legacy program that's been around for a long time, but now really has been taken, I think, to the next level. And then some of the other things that have grown out from that are improved processing times. Certainly, we are very excited to be seeing USCIS approve newly filed I-526E petitions in the rural set-aside as quickly as they are. There are approvals coming through in as little as 3 months, but it seems like USCIS is settling on something certainly less than 12 months, which is a significant improvement in terms of historical approval rates for sure.
Yeah, I mean, when, even investors in 2019 have had huge waiting times of 3-4 years, and to see people getting their I-526 approval in 10 months, 11 months, 12 months, fantastic, and even less than that in some cases.
Yeah.
Obviously, there's other things that we'll dive in and talk about more specifically, as you mentioned, the rural set-asides, the concurrent adjustment of status for people who are already in the US. But let's, I think before we could easily jump into those subjects and spend a whole hour talking about them. Let's make sure we're covering off for folks that are new to EB-5, the real basics. So Nicolai, what I'd like to do, you mentioned that the program started in 1990. The 5th category of employment-based visas is part of the immigration code. That is a permanent part of the immigration code. The Regional Center program, which allows investors to pool their capital and invest in a project that creates at least 10 jobs per investor, started in 1992. And that's what's, if you look back in the history, had stops and starts frequently, basically because it was attached to the government appropriations or funding bills, and the government would go through stops and starts while Congress figured out the full omnibus spending bills and appropriation bills. But over the last 10 years alone, over 70,000 visas have been issued to families. So it is a big program. It is a established program. And as we just said, now we have a 5-year reauthorization with clarity and a lot of new rules and regulations and policy that actually the industry welcomes. So let's just do a quick back and forth on some of the characteristics for people that are newer to the program. So first of all, the key benefit, of course, is being able to work, live, and travel in and out of the United States. Who gets the benefits?
The benefit is available to what we call the principal applicant, or the PA, and his or her qualifying dependents. And qualifying dependents is defined as a spouse and unmarried children under 21 years old.
Excellent. And how long does it take to get a green card? Obviously, we were just talking about processing times, but when you're talking to a new client, how do you set expectations on how long it takes to get a green card?
Yeah, generally it's a 2-stage process. So the first stage, and we'll get into this in more detail with a timeline and so forth, but just generally speaking, you file an I-526 petition that's filed with the USCIS. And then if you're outside the United States, which is most common, once that's approved, then you need to consular process. So eventually you'll have an interview at a consulate. You'll be issued a visa that allows you to travel to the U.S. When you enter the U.S., that visa will be stamped by Customs and Border Protection. And at that point in time, you actually become a green card holder. Later, you get the green card sent to you in the mail, and it's going to have as a start time that same date that the visa was stamped. So that whole process, I-526 approval, we're estimating around 10 to 11 months if you're investing in a rural project. And then the consular process typically takes between 3 to 5 months, depending on how busy the consulate is and how quickly you can schedule an appointment. We will discuss an alternative to that called concurrent filing, but that's a little more complicated. So why don't we save that one for later in the webinar?
And I wouldn't be surprised to see a few questions come in on that. I know we've had a lot of clients ask about ways to come to the US on other visas so that they can do concurrent adjustment of status. But before we get to that, how much is the investment amount? How many jobs need to be created?
$800,000 now. If you're investing in a targeted employment area or infrastructure project, otherwise it's $1,050,000. And you have to create 10 jobs for U.S. workers. Now, one of the unique features of the regional center program is that the way you can evidence the creation of those jobs is more liberal, if you will, than it is in the what we call standalone EB-5 structure, where you're running your own business. To prove job creation in the regional center program, you can rely on economic methodologies measuring indirect and induced jobs as well as direct jobs. So it's much easier to meet the job creation requirement in a regional center investment structure.
Yeah, so we often refer to a direct EB-5 direct, which is that original one where the jobs do have to be W-2 jobs and full-time, 10 people over at least 2 years, or through the regional center where you also get to account for or count construction jobs, subcontractors, people that help the project come to life that aren't directly hired by the new job creating enterprise. Excellent. So I think it probably makes sense, again, just for people who are newer to the program, to put up a quick diagram and we can kind of talk through that timeline that you were just referring to. So if you bear with me 1 second, I will share my screen. And you should all be seeing a EB-5 timeline now. And for those who are listening on their phone or otherwise, we'll also talk through it. So there's 2 tracks that investors need to consider when they think about the EB-5 program. One track concerns their investment, and that is a private equity investment in a fund that invests in a project that creates jobs. This is dictated by a private placement memorandum, a PPM, and is a contractual relationship to put money in a fund that is then either loaned or invested in a project. And it has a timeline, a contractual timeline. That's typically 5 years, and some have extensions to 7 years. That's the reason the projects do the whole program and engage in the program, is they're using the capital to do a project they might not otherwise do. And they're using it to get projects moving, which in turn creates jobs. The second half of the timeline, of course, is the one that frequently our investors care more about, although obviously return of capital is very important, and that's the immigration timeline. So Nicolai, I'll let you run through the bottom half of this diagram. I gave you the hard job, I'm afraid. If you can talk through the steps in a little more detail so people can understand.
Yeah, it is a little complicated. I apologize beforehand, but this is a good illustration, so hopefully it'll help people visualize the process a little more easily. So the first step is you decide you want to invest in EB-5. What do you do? First of all, you need to get a good attorney, whether it's me or another attorney. You want to make sure that the attorney you choose has specific experience in EB-5. EB-5 is a complex area of immigration law, and just because an attorney has maybe years or decades of immigration law experience, that does not necessarily translate to EB-5 experience. So once you retain an EB-5 attorney, we will begin the work necessary for the documentation, for preparing the documentation that has to be included in the I-526 petition. That is the first step in the EB-5 process. That is a form that is filed with the United States Citizenship and Immigration Service. The I-526 used to have two components: information about the project you're investing into and information about how you earned the money to make that investment. Now we can more or less leave out all of the project documentation because USCIS incorporates that by reference, which is very helpful. So primarily we're focused on, at this stage in the pre-work for filing, strategizing with an investor about how they're going to fund the EB-5 investment. And I won't get into too many details. This is a pretty complicated and fact-specific exercise, but the government approaches lawful source of funds as a two-step process. First, they want to know what is the source of the money that you are investing? How did you earn that money? And secondly, the path of funds. How does that money move from the source all the way until it's invested into the new commercial enterprise? So that process typically takes about 1 to 2 months. We can certainly do it faster and have done it faster. It depends on how motivated the client is and of course, how complex their source of funds documentation is, how many thousands of pages we may need to submit. In many instances, these I-526 petitions, just to give you a sense of the scope of the evidence, are 1,000 to 2,000 pages long. So it's a lot of very detailed information. Okay, so we file the I-526 petition and you get a receipt notice with the USCIS. And that is a very important step in the process because that establishes something called a priority date. So the priority date is essentially your date in the line of people who are filing I-526 petitions. And it's particularly important for people who may come from countries that are subject to retrogression in the EB-5 category. Right now, that's going to be Chinese and Indian nationals. They're subject potentially to a future wait line, even in the new set-aside categories. Right now, there's the existing investors from India and China are retrogressed. New investors are not, but it's important to know that your place in line is dependent on when you file. So if you're interested in EB-5 and you're from China or you're from India, my advice to you is to file as soon as possible because you get the better priority date. Now, I mentioned earlier that typically the next stage is done after I-526 approval. So if you're living outside the U.S., you are going to consular process, and that process more or less doesn't start until the I-526 is approved. Right. And then what happens when you consular process is, as I mentioned, you go and you have an interview and you get a visa put in your passport that allows you to book a flight to the US. You land, let's say New York City, wherever, and you're admitted, and your visa is stamped. And when it's stamped, you become a conditional permanent resident. Well, let's say that you are already living in the United States. So we have many clients that are here in the US, either on an H-1B visa or as a student, or sometimes even as a B visitor. And they decide that they want to file an I-526 petition. Well, if they're in the United States in valid non-immigrant status, and a visa is immediately available to them, so that is to say there's no retrogression in the applicable category, they can do something called concurrent filing. And this is tremendously attractive. The benefits of concurrent filing are very significant, and we are very, very pleased that the Reform and Integrity Act made this a new possibility in EB-5, because it wasn't until the passage of that new legislation. So what does concurrent filing mean? When you file the I-526 petition, along with it, you can file something called an I-485. And the I-485 is asking the USCIS to adjust someone's status from non-immigrant, say H-1B, to immigrant status, the green card status. Now that I-485 cannot be approved until the I-526 is approved. So it's going to remain pending until that point in time. Then USCIS turns to the I-485, will adjudicate that, and when they approve it, on that date of approval, an individual becomes CPR, conditional permanent resident. The huge benefit to concurrent filing, though, is what you get during that period of time. While the I-526 and the I-485 is pending, you can also obtain work and travel authorization. So you file an I-131 that gives you travel authorization. We call that advanced parole. And you can file an I-765 that gives you work authorization, totally independent of an employer or anything. So if you're an H-1B worker and you think you might be laid off, or you want to find another job and you don't think that your new employer will help, port to that new employer for purposes of maintaining the H, you can work on your EB-5 based EAD. And so the work and the travel authorization will be approved and last during the whole time the 485 is pending. So think about that. What is a green card at its root, right? It is the right to live and work and travel in and out of the United States. And in some ways, you are really able to get the green card benefits before the issuance of the green card. And the government has decided to give people that benefit because they're already in the United States. They're already contributing in some ways to the economy of the United States, and the government has made a policy decision that it's the right thing to give people who are already here, these pretty significant rights, totally independent of their underlying non-immigrant status. So those rights, so what you file all of those 4 forms together, right, at the same time. So the I-526, the I-485, the I-131, and the I-765, all together in a very big box. Now we're talking, 4,000 or 5,000 pages of documentation usually. And the first thing to be approved will probably be the EAD card, that is work authorization. We're seeing USCIS take between 3 to 5 months to approve that. And that is, of course, usually the most important thing that people want right away. They want to be able to work as quickly as possible. So USCIS now issues those EAD cards with a validity period of 5 years, which is great. You may also receive the same, or that is the advanced parole typically these days is being adjudicated about 9 to 11 months later. And so you will get the advanced parole approval on a separate card from your EAD card. Sometimes they are included on the same card, and we call that a combo card. We've gotten a few of those recently, but for the most part, USCIS prioritizes adjudicating the EAD and then takes a little bit more time doing the advanced parole.
So Nicolai, if I just jump in, all of those steps, and I know there was it sounded probably like a bit of complexity there. Those are for people who are already in the US.
Yes.
And, and so that a common scenario that we see is a student in the US on an F1 visa who decides to make an EB-5 investment so that when they want to look for work, they don't need to be sponsored. And literally, a student could arrive in the US on an F1 visa, make an EB-5 investment, and have a work authorization before they graduate their freshman year or their sophomore year or their junior year. And then have the travel card follow quickly thereafter if they don't end up with a combo card.
Yeah, absolutely. It's hugely powerful, right? It is now an immigration strategy that just didn't exist before for students. So I have a lot of my clients are graduate students. They've got an LLM and they're working for big law firms in New York City or Washington, D.C. They're on OPT. They didn't win the H-1B lottery, and they have no option really to stay in the United States other than EB-5. By filing an EB-5 petition, they can get work authorization and continue their career with these white shoe law firms. They wouldn't have that option otherwise. So it's tremendous.
And that can extend also to not-for-profit, if a child wants to work in the arts, if the child wants to do a startup. All of these are options you can do, because with that EAD, you effectively have the right to work wherever you like.
Correct. Yeah.
So let's jump back for foreign nationals that aren't in the US and talk about that process. So after the I-526 filing, and you can see that line going up to the funds being dispersed. As a fund manager, we hold capital in escrow. So in other words, it's completely under your control through the escrow account until your 526 has been filed and we've received a receipt from the USCIS, from the US government. On receiving that receipt, that's when the funds are dispersed. And then during the period that you're going through approvals and authorizations and having a green card, which we'll talk about for a second, LCR is managing, is effectively your voice or your representative to the developer, because we have separation. And we do that purposely to represent your interests and also provide reporting, K1s and so forth, until you file your 829, and that's when the investment is returned. So Nicolai, if you jump back in, the I-526 approval has come in, celebrations around the world. You mentioned you quickly go to a consular interview, and then at that point you move to the US. Talk a little bit about those 2 years of having the conditional green card, the sustainment period, as it's called.
Right. Yeah. So you travel to the US, whether you are traveling on a visa or if you are already there, as I said, then what triggers CPR status, conditional permanent resident status, is approval of the 485. But at that point in time, you become a conditional permanent resident and you can live lawfully and work lawfully in the United States. The CPR green card has a validity period of 2 years. So many of my clients will, let's say they're consular processing, moving to the United States is a pretty big thing, right? So they don't typically move immediately. They'll come in, maybe they will stay for a couple of weeks, look for a house, get driver's license, open up, get bank accounts, etc., and then they'll return back to their home country. So there's not a requirement that you sort of stay in the United States for a specific period of time in order to validate, if you will, the CPR card, that status. you can travel in and out. Now, there are requirements on maintaining your residency, so you can't leave the U.S. Preferably for more than 6 months, certainly not for more than a year without having some issues. In those instances, we can file something called a reentry permit if people know they're going to be outside the U.S. for an extended period of time. But generally, people are just living and working and establishing their lives during that 2-year period. Within the 90-day window of the expiration of that 2-year period, you start the third step in the EB-5 immigration process, and that is filing the I-829 petition to remove the conditions on the green card. Once you file that, you will get a receipt notice that automatically extends your CPR status for another 2 years. So in fact, typically, historically, people have actually spent more time in CPR status. You're not just in CPR status 2 years. Typically, it's about 4 to 5 years. And then USCIS will approve the I-829 petition, and then a person will be they'll have a permanent green card. I should mention there's really no functional difference between CPR status and PR status. In fact, the time that you spend in CPR status counts towards the time required in order to file for citizenship. So you can become a citizen 5 years after having a green card, and the period that you're spending in CPR status counts towards that. So USCIS is not as fast in adjudicating I-829. I could say that charitably. We would like to see them speed that adjudication up. I think partly that is a function of resource allocation. So we were celebrating the faster processing at the beginning of the stage earlier on this call, I-526 adjudication significantly improving, and that's a great thing. I think USCIS feels less of a sense of urgency for I-829 petitions because functionally there isn't really much difference between a CPR card and a PR card.
But there is an interesting point to be made about the capital return there. Traditionally, in the early days of the program, capital in the contract that dictates your investment in the limited partnership were stated to be done on receiving approval of your 829 was when capital would be returned. As those timelines stretched out, we had guidance from the government that actually capital could be returned on filing the 829. And I know for LCR, with one of our funds, an older one, we actually sent out a notice to all of the limited partners to change that we would be paying back on filing instead of on receiving approval of that final 829 form. Just this past month, we've received notice that actually the government allows payback if the sustainment period has been met. So that's 2 years. Now, many developers can't take capital for only those 2 years and pay it back. There's few projects that can do that, and if they do, often they're more risky. But it does open up for us to be able to pay back to the exact term of the contract, which we like. So you agree to put your money into the partnership for 5 years, 4 years, and when you hit that time, you're no longer bound by waiting for USCIS to do a step. We'd be able to repay capital.
Yeah.
Okay, so let me stop sharing, of course, and you also answered the question we frequently get, which is how long after this process do you then wait 5 years to citizenship? And the answer is no, it's 5 years from the time you get your first conditional green card.
Correct, and you can even file your application, even if you're still in CPR status. You can still file the N-400 seeking citizenship, and it'll just remain pending until your 829 is approved.
So we do have a question here about that kind of mixes the concurrent adjustment of status and the B1, B2 visa. And the ask is, so it's a family, husband and wife. The husband is here in the US on a B1, B2 visa. would love to do the change of status, but wants his spouse to be the primary applicant. She's outside the US. I love these scenarios. By the way, this is why you enter into a contractual relationship with an immigration attorney.
Yeah.
Nicolai, if you have a spouse who's outside the US, obviously, first of all, you have the question, can you do an EB-5 concurrent adjustment of status on a B1, B2 visa? Have you had success with that? Because I know that that's an open question.
Yes, there's no question you can do that. The more thorny question is sort of how you do that and what happened before you actually filed that petition. And to understand why that is the case, I have to explain a little bit about the intention that is required, that the government requires when somebody is entering the US on a non-immigrant visa. Generally speaking, you have to have non-immigrant intent when you enter on an F visa or a B visa. What does that mean? That means that when you enter, you are supposed to intend to return to your home country or another country outside the US. You're coming into the US for a limited period of time with the intention to depart. Of course, if you are entering with the specific intention of filing an adjustment of status petition, that is arguably inconsistent with that required intention. So I cannot advise somebody to, in the scenario that you mentioned, and again, I'm not giving legal advice, but I would be comfortable filing for the husband who is already here and perhaps has just discovered that it is possible to file concurrently if he's here in B, because he had entered in B not knowing this was possible. The wife that is outside the US, that's a very different scenario. Some people may counsel that if you enter and you wait 90 days, that's a sufficient period of time in which to have changed your mind. And that may be the case, right? That is not a rule. A lot of people think there's a 90-day rule. And I won't get into the details of that, but suffice it to say, there's no such rule. USCIS can look at these cases and can ask questions about intent. But if you are able to point to some change in your circumstance that happened after you entered that led you to want to file the I-526 petition, then perhaps you can file in B status. But it's very fact specific and certainly something that you want to talk to an experienced immigration lawyer about.
And of course, if a spouse is outside the US and files their EB-5 while outside the US, then they go through the outside the US process, which is waiting for approval, consular interview, and then moving to the US.
Yeah, exactly. I mean, they could come in later and still file the B, but I think what people need to realize is that, they are putting themselves at risk potentially by doing this. And the EB-5 green card, any green card, this is a long-term objective and a long-term goal. And why jeopardize a long-term sort of goal by a very short-term gain? The second thing I would point out is people have to realize that if they enter on a B, and let's say we have them wait 90 days, which many immigration attorneys would insist they do, they also have to wait for their advanced parole to be approved before they can leave the US, right? So I mentioned that's taking about 8 to 11 months. Well, you add up the 90 days and the time that they have to wait before advanced parole approval, and they are stuck in the United States for at least a year. They cannot leave the US. If they do, if you leave the US before the I-131 is approved, the 485 will be denied. So that's a significant period of time to be stuck in the United States. If there's a family emergency, maybe they can get emergency advanced parole, but it's certainly not guaranteed. So with that kind of limitation, and with the fact that I-526 petitions in the rural category anyway are getting approved so quickly, you're actually most likely going to get the final green card more quickly if you consular process. So people don't realize that. You may get the benefits of concurrent filing for a period of time, but the actual green card in the concurrent filing structure also requires the 485 to be approved. And there's a time frame for that. I think USCIS currently it's over a year. Whereas if you consular process, you know, the I-526 is approved, you go and you have your interview, you get the visa and your passport, and you land in the United States, and that visa is stamped, then you are a green card holder. In the concurrent filing structure, once the I-526 is approved, then USCIS turns to adjudicate the I-485, and that's likely going to take longer than consular processing.
So there's obviously a lot of steps and a little bit of complexity there, and we also have seen clients who come to the U.S. and take a course. So, for example, a spouse comes and takes a course, receives an F1 visa to do that, and then becomes the primary applicant. But the big shift here is that the processing time isn't 3 years or 4 years, as it's been in the past, where people outside the US were waiting for their approval. If we continue to see, and we expect to, USCIS maintain a cadence, particularly with rural projects, of 10 to 12 months, then a lot of these strategies, as you're saying, it doesn't become necessary. You can do the straight invest from outside the US, go through the consular interview, and move, and have all that happen in a year and a half.
Correct.
Yep.
Yeah, I was just going to mention, I mean, this is something even for my non-EB-5 clients that are eligible to adjust status in the US. Sometimes we elect or the family elects to all fly back and consular process together because at the end of the day, it may be faster.
So we have seen a few people raise their hand. Obviously, please use the Q&A. That's the easiest way for us to take questions. We do have one here that asked about the fees. So I've pulled up a page from our EB-5 introductory brochure, which I'll share here for a second, and we can talk through them. Just give me 1 second. Here we are. So these are sort of what we call representative economics or fees and costs for investors, but it does give a quick summary. So there are fees that are charged by USCIS. These are paid directly to the government, and those total out at about $8,000. There's an integrity fund fee that's also a US government fee. Typical costs on an immigration attorney, Nicolai, I don't want to put words in your mouth, but we've been using 30,000. So that you're nodding, which is good. You know, I know that at times you can do things cheaper, and at times there are really difficult situations with source of funds and complicated family situations that may push those costs up. Yep.
Correct.
The administrative fee that all projects have covers a lot of the costs of your processing and the people that are advising you. These vary. They, typically we use as a placeholder 70. A number of our projects are actually at 60. Some projects in the market are at 80,000, and that obviously can be discussed. Once you've invested your capital, there is a return. The return is not the return you would expect, say, in a private equity fund, a real estate fund, where you're not receiving an immigration benefit. The return tends to be under 1%, or today with the higher interest rates, around 1%. You do sometimes see projects that have much higher returns, but they often have a lot more risk associated with them. There's a reason why they're putting that interest return so high, and it's because there's, you have to recognize that you are risking the capital coming back to you if you go into a riskier project. We like to say at LCR, the government requires that your capital be at risk, but that doesn't mean it has to be risky. And we can obviously talk to project selection and evaluation. There's a lot of things around guarantees for different scenarios, and of course, just the pure business plan behind the project to give you comfort that yes, at the end of 5 years, your capital will be returned to you. The net is that the total cost is about $70,000. And when your capital is returned, when you think about doing this for a child so that they don't have to go through sponsorship, that is less than 1 year of university in the United States. If you think about it in terms of moving your whole family to the United States, what we call full family migration, it's a small expense against such a big life change. And of course, the benefits that come from living in the U.S. Anyone who's on this webinar understands why they would, why that's appealing. Any comments on that, Nicolai? Does it look straightforward?
Yeah, I agree with all of that. Typically the people are focused on three things in EB-5: their immigration benefit, capital return, getting their capital back, and then a potential return on the capital. And I think you rightly said, the higher that rate of return, typically the higher the risk.
Yep. Excellent. So let's turn a little bit. We've got about 10, 12 minutes. We've been answering some questions here. Again, if people have other questions, feel free to put them in the Q&A. Anna's also on the webinar to answer any questions that aren't appropriate or aren't aren't going to answer directly to you through the webinar. We've talked a little bit about the application process. Let me turn to that quickly, because I know that it's a question that frequently comes up. It's like, okay, so I understand it, and I'd like to just do this really as quickly as we can, because I do want to also talk about some of the more sophisticated things that are questions from our investors. But this is a summary that we use of the application process. And I think, Nicolai, you talked through a bunch of these steps. You talked about the source of funds evaluation that you do. We also actually have some tools and tricks to help you evaluate your source of funds, not doing the actual documentation, that's done with your immigration attorney. But we often find that clients, when they engage you, they would like to be as educated as they can about their choices. And so it's some tools about, evaluating different choices for source of funds. Obviously, receiving the full project documents, that can happen quite quickly. We have a document request form that can, where you state or confirm, self-certify that you're an accredited investor, and that allows us to give you the PPMs and the documents around a project. Typically, we work with you to figure which project makes the most sense for you. Engaging an immigration attorney. And why don't you, Nicolai, you talk through just the last steps there, because once they engage you, you take the lead on helping them put together all their documentation until they're ready to wire capital and file.
Yeah, that's right. So typically what I'll do after being engaged is schedule a conference call with the client and any advisors that the client might have, wealth advisors, accountants, etc. And we will discuss one or more funding options for the EB-5 investment. Some clients have 5 or 6 different ways they could fund an EB-5 investment, and we will discuss those options, and typically we'll defer to the one that's most simple. We like to keep things as simple as possible for the USCIS. That's not always possible. I'm finishing a case here that has, I think, 21 different sources of funds for a family. Some families, they save and they're well off, but they're not ultra wealthy, so they don't have a lot of options. But that's fine. They've saved money and they have money invested in various securities and property and so forth. And so we work through that and come up with a strategy. Based on that strategy, I'll generate a document request list. And then people start working on fulfilling those requests, uploading them to our share file, and then we review that. And usually there's a little bit of a back and forth as we're working our way through those documents.
I know that one of the kind of more sophisticated things we talked about, let me just stop this share, that comes up for a number of countries is the foreign exchange process. So clearly, China and Vietnam both have strong restrictions. Pakistan has introduced new restrictions. India has its LRS process. You know, everyone understands that the source of funds needs to be well documented because they can understand that the US government, doesn't want to see cash coming into the US that hasn't been well documented. But frequently people aren't aware that you also have to document the path of funds. So how did the investment come from where it was to the US? And just as an anecdote, we had a European client who chose to pull some of the capital from a trust. And actually, that ended up being a little bit of he had choices. He had earned his the capital as an investment banker in London, very clean, very well documented. But he just chose the trust because he thought that was the easiest way to do it, and it ended up giving him a little bit of a wrinkle. But coming back to the foreign exchange, how do you counsel people who do need to move money into the US and or convert it into dollars?
Yeah, so I am limited to my ability to counsel in foreign jurisdictions. So I can only counsel to the extent that any such transaction involves U.S. Immigration law. But we are aware, of course, of strategies that people use in order to move money out of countries like China and Vietnam and India. And we can advise, on USCIS's treatment of those approaches and talk to the clients about perhaps alternatives in some instances or how best to document those transactions. It's probably most difficult in Vietnam. I think as a Vietnamese citizen, you can transfer out $7,500 a year, something like that. China is about 50,000, and India's system is much more liberal. It's 250,000 per family member. So it's much easier to structure this for Indian clients than it is for clients from Vietnam and China.
But the key, of course, is using an established foreign exchange, using an established bank, and so forth, and having clear documentation.
Exactly.
So there is a question about project selection from Umair. So we do quite a lot of work on helping people evaluate different projects, and we can talk to that as well. I mean, there's a huge variety, to be honest, and some are more focused on security of the immigration benefit and the jobs created. Some are more focused on the quality of the parent, so capital security. We try to put those together. There's a few questions that we recommend clients look and ask, things like, has construction started? Because you can invest in a project, and then if the construction is halted for permits or other reasons, then the jobs won't be created because the project doesn't move forward. That's a classic thing to check. Obviously, like any investment, ask the question, about the business plan. If it's a multi-use hotel, is it in an area that's seeing growth? Does the parent doing the development have experience in building this kind of project? Do they have deep pockets that can support the project if there's any adversity? Job creation obviously is about is in the PPM. There's always an econometrics report as part of the filing, and there you can dig into what they're projecting. That tends to be done. Many of the people doing those econometric reports and business plans are from USCIS. It's interesting in the industry, so they know exactly what the government's looking for when they evaluate them. I mean, Nicolai, do you end up counseling clients on that documentation? I think generally you would stay away from project selection, or
yeah, I do.
I'm sure you get the questions.
I get the question almost on every consultation and every interaction with a would-be EB-5 investor. And my speech is as follows. I can only advise on immigration law. To be an investment advisor, I have to be licensed by FINRA, and I'm not. So I can't give you specific investment advice on a project. That said, I can certainly talk about immigration aspects of players that are in the industry and regional centers and so forth. And we can talk about the immigration aspects of a project that are in some ways tied to the investment. but not, I guess, directly. So job creation is one question that I get a lot. What's the job creation risk here? What are the job creation projections? When are they going to be created? What does that mean for my I-2 non-petition, et cetera? So those kinds of questions are ones that I can get into, but I am limited, and I do not tell people, you should invest in project X or project Y.
Yeah, and you can also explain some of the immigration guarantees, guarantees that if your 526 is presented and declined, how that might happen, and then the client can understand from the documentation what would happen in terms of their return to capital or things like that.
Exactly. Yeah. As long as it's under the umbrella of immigration law, I can talk about it.
Excellent. And so a second part of this question was, can someone invest 400,000 and not the full 800,000? We call that tranching or partial payment. And yes, it is accepted. There was clear guidance from USCIS that it is accepted. A couple things about that. And we also have worked that into all of our projects to allow investors to make 1, 2, or at times 3 payments. A couple things that are interesting on this. First of all of the investment, the full 800,000 plus any admin fees and other fees associated with it, need to be documented. So you can't just document 400,000 and file. You need to document the full amount with your immigration attorney. The second piece is that the full investment has to be made when you are adjudicated. Now, in the past, that was often 2 years, but now it's happening in as much as 10 months. So, I mean, Nicolai, correct me if I'm mistaken there. You have to have your full investment in when your file comes up for adjudication.
Yeah, I mean, there is some language that says in the process of investing, but I've never successfully relied on that in an I-526 adjudication. So I think that if the client has not fully invested by the time USCIS gets around to looking at the I-526, they would issue an RFE and say, please show us the full investment has been made. So yeah, and as you said, it's critically important that you present a full plan of investment. You can't just be, I can source 200,000 and I'll come up with a plan for the 600,000 later. That said, certainly you want to be sure that whatever it is you represent to USCIS as the final funding strategy, in fact, is that final funding strategy, because you don't want to paint yourself into a corner where you're not going to be able to fulfill what it is you're representing to USCIS. But it is a nice feature to be able to have the option of a partial investment, particularly, again, for people who are from countries that potentially may retrogress in the future, or for people who have, who are in the US, like let's say a kid is about to graduate or their OPT is running out and they really want to file, and it's going to take them some time to get the full amount. Maybe a house is being sold somewhere and they don't quite have all the money. In those scenarios, it makes a lot of sense to file the 526 so they can immediately start waiting for those benefits that are going to be eminently approved by USCIS.
So there's a few more questions, if everyone can hold for a few more minutes, about the investment. So one very good question is, can I borrow money? It's interesting. We know that a source of funds, the typical sources of funds are income from business or employment, or from a business that you have ownership in. You also have the option of being gifted money from a family member. And can you talk to loans? If someone were to have a loan from investors for the 800,000, that one I don't believe I've seen.
Yeah, you can definitely borrow money. And in fact, there is a court case that turned over prior USCIS adjudication standards requiring any loan to be securitized by personal assets of the investor. And we always thought that was a fundamental misreading of EB-5 law. And luckily, courts agreed with the industry and removed that requirement. So you can have an unsecured loan. And, when I think it's credible to get a gift from a blood relative or a close family member, but it doesn't seem likely that even if you have a very good friend, I have very good friends, I don't know any that would lend me $800,000 or gift me $800,000. Let me be clear, they would probably lend it to me. And that's fine. It's absolutely fine for them to lend money, a friend or even a relative. But USCIS will want to know where that friend has gotten the money to make the loan. So essentially, the entire source of funds analysis shifts to the person making that loan. If you're going out to a bank and you're mortgaging your house, USCIS is not going to ask, well, where did HSBC get the money to make that mortgage loan? But if you're going out to a friend, they're certainly going to want to know where that friend got the money to make the loan.
And that hits the other question we have that just came in here, which is, if I'm leasing property or selling property, do I need to prove the source of funds for where I purchased the property? And the answer there is yes, you do. And that actually becomes tricky, isn't it? If it's like a family property that's gone back quite some time, and you have to come up with the documentation to show where the original capital came from to buy the property.
USCIS is pretty charitable and reasonable about this. So they understand that if a property was purchased 30 years ago, the expectation is not that there's primary documentation available to show, bank transactions and so forth to substantiate a person's ability to purchase that property. We talk about something we call a pattern of income sufficient to purchase. So where you're looking at property that's been purchased so many years ago, we are relying oftentimes on secondary evidence, whatever may be available at that point in time to substantiate their ability to purchase that property. Now, if they bought the property last year, the analysis is going to be a little different. The expectation there is that you're probably going to have primary bank records showing money out. So it's going to be a much more detailed analysis. And this ties into the whole strategy discussion, right? So if somebody has multiple properties that they might sell or mortgage for EB-5, it's advantageous to use the more aged properties given the standard of evidence USCIS expects to be available.
Fantastic. So Nicolai, wonderful conversation, and I hugely appreciate you taking the time. I hope that for everyone who's still on, and most are, that we did cover kind of some of the basics, but also dive into some of the real specifics about the EB-5 project. And we had the ultimate compliment come across on the Q&A, which is, wow, this has been a great session. I really want to meet you guys. When can we get together? Thank you for that. That is why we do it. I think obviously Nicolai as an attorney is an advisor and looks to be a trusted advisor, and LCR, as much as we're a fund manager, that's our core brand concept, that we're a trusted advisor to you and we represent you in the financial transaction. With that, I think we can close up. Nicolai, thank you, and look forward to doing more of these and working together in the very near future.
Likewise, John. It was a lot of fun. Thank you.
And thank you all for joining.